KTN News.
All right, so there you have it. Tomorrow, the people, the residents of the two constituencies will be casting their ballot once again to elect their new members of Parliament. But then, Attorney General Paul Kihara Kariuki has filed a notice of appeal against the High Court judgment that declared BBI process unconstitutional, null and void. This happening as the proponents of BBI line up a battery of lawyers to battle it out at the Court of Appeal. KTN senior political affairs reporter Jeff Kirui with that report.
Nobody can stop reggae. Thursday's momentous judgment by the five-judge High Court bench put in motion a series of events that are set to end up at the Court of Appeal this week.
Neither the President nor any state organ is permitted under our Constitution to initiate constitutional amendments using the popular initiative route.
In a petition by Solicitor General Kennedy Ogeto, Attorney General Paul Kihara Kariuki has declared an intention to appeal the ruling under a certificate of extreme urgency through a notice dated 14th of May, a day after the High Court ruling was delivered. The Attorney General is seeking stay of implementation of the orders of the ruling by the five-judge bench pending hearing and determination of the application. The move by the AG is the preamble of a fight-back plan by proponents of the BBI seeking to steer the train back on track.
Tunaendelea. Kwa hivyo BBI haijaanguka.
Meanwhile, a caucus of members of the county assemblies have raised concerns that should the ruling of the High Court be upheld, then Kenyans will be shortchanged.
We demand the following, that judiciary stops robbing Kenyans of their direct sovereign powers or abusing the delegated indirect powers donated to them by Kenyans.
Critics of the BBI process have however lauded the move by the High Court.
Hata hawa wakienda appeal, it will be very difficult for it to succeed. And I think the judiciary has really assisted Kenya.
BBI proponents have engaged a battery of lawyers in a bid to overturn the ruling by the High Court. The lead lawyers being Paul Mwangi and Professor Ben Sihanya on Raila Odinga's side, and the Solicitor General Kennedy Ogeto together with AG Paul Kihara Kariuki on the President's side. Jeff Kirui, KTN News.
All right, so that story by my colleague Jeff Kirui leads us to a discussion with a guest this morning, and I'm talking about lawyer Omwanza Ombati, who is supposed to be telling us what this means for Kenyans and what it means for the BBI proponents. Wakili, good morning, and thank you so much for joining us here on KTN News Center. So first, even before we get to the fact that the team BBI, pro-BBI team, are saying they're moving to the appellate court, the question in the minds of many Kenyans is, couldn't the BBI committee that was composed of lawyers and also the legal team of the two principals, I'm talking about Honorable Raila Odinga, ODM party leader, and President Uhuru Kenyatta, they have a legal team. Couldn't they see these loopholes that the five-judge bench mentioned during the ruling that they were giving last week on Thursday?
Well, that's the question on everybody's mind. How could such distinguished lawyers miss such basic constitutional steps or missteps and let the president drop into a minefield, including Raila Odinga? So the issue really is not whether they were able to miss it or not. I think is they were not able to give good legal advice.
And so what does it really mean? Because we're seeing some of the team, the team that is talking about, some of the members of the team that is talking about going to the appellate court, it still constitutes, the BBI committee members. You're looking at the likes of Paul Mwangi, the likes of Ben Sihanya, and now we are seeing the Attorney General and also the Solicitor General has joined this a legal battery of lawyers who will be representing the team BBI. What are they likely to pick out from that ruling that will actually make them, convince the appellate judges that indeed the five-judge bench erred in their decision?
Okay, I've had an opportunity to look at what Kennedy Ogeto has filed, and you will notice that what he has filed is an application before the same High Court, not in the Court of Appeal. So he's yet to file an application for stay in the Court of Appeal. So he's gone before the same High Court, asking that they stay their decision pending his filing of the appeal. In my opinion, I don't think he will succeed in that part, because he's going before the same bench and telling them, can you stay your decision as we go up on appeal? So on that part, I don't think he'll succeed.
So Akili, what you're telling us is that there's no likelihood that the court, the Constitutional Court that gave that ruling on Thursday, will likely give a stay order.
Yes.
And if they fail to give that stay order, what is the next step? Will they proceed to the Court of Appeal?
Yes. Now, if he's denied that stay order, because you see, the challenge he has is that he has already filed a notice of appeal to the Court of Appeal. Then he's going before the same Constitutional Court that gave those declarations of nullity. So in terms of going to the same court, he has very slim chances of success. His next step probably would be to go directly to the Court of Appeal and seek a stay based on basically three arguments: that he has an arguable appeal, number one; number two, that there is public interest in the case, immense public interest; and thirdly is that if a stay is not granted, then
all right. We have been talking to Omwanza Ombati, a lawyer, who's really trying to explain to us what this whole, the next step that the pro-BBI team is planning to take, what it means to the entire BBI process. And Wakili, you were explaining to us in terms of if the court refuses to give stay order, the next step would be going to the appellate court. But what are the chances that the Court of Appeal might overturn the ruling of the Constitutional Court?
Well, speaking as a practitioner, I think the chances are, well, they would probably be able to overturn one or two findings. But remember, the court made 17 findings. So if they overturn, say, one or two, still they are not able to succeed. The rest are able to put the BBI roadblock, and they will not be able to proceed. My view is that they have very few chances to appeal. Maybe their best chance would be in the Supreme Court.
But then the question in my mind is, Wakili, even as we look at the appellate court, it's not a complete court. And this is based on the fact that we have the president of the Court of Appeal was actually nominated to go to the Supreme Court. So what happens next?
No, the Court of Appeal is a complete court. It's only had two members who have been elevated. Well, one has been elevated already. There is a gazette notice. So Justice Oko is already a judge of the Supreme Court. He's just awaiting for him to be sworn in. But the president issued a gazette notice last week. Justice Pome went through the parliamentary process for vetting. So most probably the outcome will be known this week. So the Court of Appeal is less two judges. So as it is currently constituted, it has 12 judges, and it has the quorum to listen to this appeal.
Mm-hmm. So apart from the Court of Appeal, going to the Court of Appeal, Wakili, and you're saying that the Court of Appeal might find two rulings that might be overturned, and that will not make any difference. What are the other options? What options does the BBI team have, just apart from the Court of Appeal?
The other option will be for them to restart the entire process afresh, and taking into advice the judgment of the High Court. Meaning they now have to choose if they have to start afresh, whether they are going through a parliamentary process or a popular initiative. Because the court said there are only two ways that you can amend the constitution, either through a popular initiative or through a parliamentary process. So probably the easier option for them will be through a parliamentary process. But again, reading the judgment, you'll realize that amending the constitution is not a process you can rush through. It is a very odious.
So let's talk about, the team deciding, let's take the bill. We bring back the bill through a parliamentary process. So that means also, Wakili, if I'm not wrong, you may correct me, you're the legal mind here. it means doing away with some of the bills, the sections of that bill that would require a referendum.
So it will have to choose what we want to go through. If the bill addresses what they call the basic structure, affects certain basic structures of the Constitution, according to the judgment, then they would need to go through a referendum. The easier process is for them to pick things that are easy to do, go through a parliamentary process, and then hopefully they'll succeed.
Then, Wakili, going through this referendum process that you've mentioned, as much as using Parliament as another route, as another, if I may say, quote-unquote, shortcut, as a way of trying to implement this whole BBI reggae, this talk that's been in the country for some time, going through that parliamentary process, then again you're mentioning there's some sections that might need going through a referendum, then it means starting the process again. But will they have a timeline? Will they have enough timelines, enough time actually to implement this BBI, the BBI process? Because we are heading towards a general election.
I don't think so, because the biggest challenge now to the BBI proponents is time, and the clock is not. The clock is running; it's not going to stop, and they cannot amend the constitution less than 12 months before the general election. So, I mean, whichever way you look at it, they have a huge hill to climb, and many minefields. It doesn't mean that even if they went through a parliamentary process, it cannot be challenged in court again. So what the court says, this is a thoroughly consultative process. You have to go through certain steps for you to be able to meet the threshold to amend the constitution.
Wakili, as we end up this conversation, you're saying something?
I'm saying whichever way you look at it, time is the biggest challenge. Time will be the biggest factor.
All right. So, Wakili, as we bring this conversation to an end, when we talk about taking the initiative through Parliament and trying to get rid of some sections of that bill that would require a referendum, what sections are we talking about exactly? Because, first of all, the court ruled that Parliament cannot direct IEBC to bring in 70 new constituencies, to delineate the 70 new constituencies. So which sections of the bill are we talking about?
That is one of them. That would be under Article 89. So in terms of amending or bringing new constituencies into operation, that cannot work unless you go through a referendum. The other one is increasing the limit of Senate and Parliament. You remember that part of the proposals for BBI was to increase MPs and senators. That also has to go through a referendum. It cannot go through Parliament, because you are affecting the basic structure of the Constitution and also the governance structure. I think the easiest, in my view, that would be is to probably work around the issue of Prime Minister, because you are not affecting the presidency, you are just adding maybe a Prime Minister and Deputy Prime Ministers. That is all. Other than that...
All right. Omwanza Ombati, a lawyer, who's trying to tell us about what is the next move for the team BBI. And Wakili, asante sana for your feedback. Wakili, I believe you're back. I'm being told you're back. Your closing remarks?
My closing remarks is that I would advise...
All right. We do apologize for that technical hitch that we're experiencing from Wakili's side during this time of trying to embrace technology, even here in the media industry. During this time of COVID-19, we're having that interview virtually with lawyer Omwanza Ombati, but he has actually explained the in-depth expectation on what Kenyans need to expect should pro-BBI team decide to go to the appellate court should the High Court, the Constitutional Court, the 5-judge bench fail to give the stay orders that are being sought for by the Solicitor General, that is Ken Ogeto. And if they go to the appellate court, what do Kenyans need to expect? And probably if pro-BBI team decide to go through a parliamentary way, what are some of the sections of the bill they need to get rid of as a way of trying to avoid going through a referendum? Wakili, asante sana for talking to us here on KTN News Center. But more of that conversation, try and grab today's Standard newspaper, because we have a full in-depth coverage for you. And we're talking about Uhuru Raila power team in BBI Fight Back, where our reporters have just given you an in-depth explanation on the team that is trying to ensure that the BBI reggae continues. It's not topped as it was topped by the 5-judge bench on Thursday as they give that ruling, stopping the IEBC from going ahead to conduct a referendum. So far, you're up to date with what is making the headlines. 9:27 a.m. here on KTN News Center. So a short commercial break, but do keep it KTN News for much more stories making the headlines.